Good morning, everyone, and welcome to this morning's Knowledge Bank. Today, we are going to be speaking about the essential pillars of effective risk management with Emma Vigus and Katharine Cusack. If you have any questions throughout the webinar, please submit them in the Q&A box at the bottom of your screen, and we are going to try and review them throughout the webinar. The webinar is also being recorded today and will be available to watch back on the News on the Block YouTube channel. And if anyone would like a copy of the slides, they will be available via email after the webinar. I'm now going to hand you over to Emma to start the webinar.
That's brilliant. Thank you very much, Vicky, and thank you to News on the Block for hosting today's webinar. 3 questions that we need to ask ourselves. Is this within the terms of our contract? Is this covered by our professional indemnity insurance? Are we competent to do this? As I speak them, these are quite simple, quite straightforward questions, but actually the response to them is often complex. Today, Kat and I are going to briefly explore why contract, cover and competence should form the framework to effective risk management within any business. We're only going to scratch the surface in this presentation. This is, as I said, quite a complex topic, but I would encourage you to ask any questions and look out for future webinars that we're going to be delivering where we explore some of the issues we will raise today in more detail. Vicky, next slide, please. Kat, if you'd like to introduce yourself.
Thanks very much, Emma. Yeah, I'm Kat Cusack. I'm a partner at RPC's Bristol office, and I specialise in defending claims against all types of construction professionals, but with a specific focus on claims against surveyors and property managers.
Great, thank you, Kat. And I'm Emma. I've been advising businesses operating in the residential property sector on specifically professional indemnity insurance since 2008. And that includes a decade running a professional indemnity partnership with the RICS. Insurance, risk management, contractual liabilities, perhaps not the most fascinating topic, unless like Kat and I, you are truly passionate about it. So if there's one thing that we want you to take away from today's webinar, it is this. Insurance policies aren't made equal. Some offer really broad cover and some offer virtually no cover. In the event of a disaster, it is, to a certain extent, your insurance policy that you rely on, both to protect your business and also quite often to protect you and your team in the case of directors and officers. You do work in a high-risk industry, so if you're not certain that your insurance policy is going to do what it needs to do in the event of an allegation, please speak to your insurance broker. And if you don't feel that they can answer the questions you are asking, please go and talk to another insurance broker. The insurance industry is fairly approachable. Good brokers, whether or not you are their client or otherwise, should always be willing to have a conversation with you and to offer you some guidance. Next slide, Vicky. So let's start to explore this topic with a simple example that I know is relevant to managing agents. And actually, it's one that's gained quite a lot of attention on LinkedIn over the past 3 or 4 weeks. If you're arranging directors and officers insurance for RMCs, I'd like you to ask yourself these questions. Firstly, are you sure that's within the terms of your contract? Secondly, are you FCA regulated, either by way of being an RICS regulated firm or as an appointed rep or as an introducer appointed rep? And really importantly, those variations in terminology allow you to do different things. You need to understand what you are allowed to do within the context of insurance. Third question, does your firm's professional indemnity cover the arrangement of insurance? Fourthly, is any income you generate from arranging insurance declared on the professional indemnity proposal form? And finally, do you know enough about insurance to determine the difference in cover between one D&O policy and another? To use an example of why that's so important, I was speaking to a managing agent a few days ago, And they routinely source a number of quotes for D&O, and I asked them on what basis they were deciding which the appropriate policy was. And their response was the cheapest. As Kat is going to cover later on, the quality of cover under a directors and officers policy varies very, very significantly. And there can be a major difference between a policy that costs £250 and one that costs £650. So if you are arranging D&O and a claim arises against the director of an RMC, are you absolutely certain that that policy is going to respond? And if the policy doesn't respond and that director finds themselves without cover, are you absolutely certain that your professional indemnity insurance is going to respond? This example might not be relevant to all businesses or all of you on this webinar today, but I promise you that the majority of managing agents will be carrying out work that when you ask yourselves these three questions, you probably shouldn't be doing. Next slide, please, Vicky. On the previous slide, we referred to the right outcome. So what actually is the right outcome? Delivering the right outcome is the best way to avoid a proven allegation of negligence and a settled PI claim. But in the event that an allegation is made, setting out to deliver the right outcome and being able to prove that is also the best way to ensure that an allegation can be successfully defended or settled, e.g. the cover is available under your insurance policy. The right outcome isn't just about doing what is right for your client or for the leaseholder. It's not always about doing what you are told to do or what you believe you must do for commercial purposes. Delivering the right outcome requires us to balance moral duty with competency and contractual obligations, whilst also taking account of the scope of insurance cover. It will require us to say no, and sometimes that can be really, really hard. We might be coming under pressure from a leaseholder to do something. We might be coming under pressure from somebody in our team or even from our manager. This isn't easy, and I think all of us, myself included, can point to situations where we've done something. We have gone above and beyond, for example, because we want to be helpful. But we really need to question the impact of doing that, particularly if we're doing something that we're not certain we're competent to do. We're not certain we have the experience to do it. We're not certain we have the tools to do the job properly. And we're not certain that it's actually within our contract. Are we obliged to do it? I'm now going to hand over to Kat to talk more about what, as block managers, you are actually liable for. Next slide, please, Vicky. Thank you, Kat.
Thanks, Emma. Yes, so I thought that I would start off taking it back to some of the legal basics, really, looking at the different ways that you as managing agents could be held liable. Not only are people often quite interested in revisiting some of these basics just as refreshers and reminders, but I think it's also really important to understand what you and potentially what a client could be liable for in the context of thinking about what type of insurance you need for the businesses. So I'm going to look at the key ways you could be liable civilly, although occasionally you could, as you know, within certain statutes be criminally liable, but within the context of your role as a managing agent. Now, one thing I would stress is I've put up on the screen tort, contract, and statute and regulations. Now, they cover the vast majority of the issues that I need to address today, but everyone will be very aware, I'm sure, of the increased and increasing role of regulators across the whole construction industry, but with a focus in particular as well on managing agents. I mean, there are so many different regulators in your industry who could have some oversight, as the RICS and the HSE and the FCA, and that is just, for starters. And I touch on this a little bit later, but understanding the risks and the possibility of facing claims by regulators is also crucial when understanding what you could be liable for and what risks you could face. Moving on to the next slide, please, Vicky. So starting off with tort, the law of tort. Now, before 1964 and this Hedley Byrne and Heller case, if you provided advice to a client and it was wrong, they couldn't do very much about it if there was no contract. Hedley Byrne and Heller changed everything. And this established essentially the law, the tort of negligence. So the Hedley Byrne and Heller established the principle that if you, in your professional capacity, provide advice to a third party, knowing that they may rely on it, and they do indeed rely on it, and that advice is wrong and they suffer a loss. Now, there are limits on what types of loss can be recovered, but let's say a recoverable loss, even if there's no contract, you can be held liable. And so that is the basic principle of the law of tort. So this is really just a reminder, because a lot of people, now I deal frequently with, I've hundreds and hundreds of claims against surveyors and property managers in my past. You will frequently still find people maybe surprised that if there is no contract there, or if they did something, for example, that wasn't within the terms of the contract, surprised that they could be held liable. So this is just a reminder, really, that even if there is no contract there, if your advice is wrong, you could still be liable. A key thing really is picking up on one of the points that Emma made just now, which is people in this industry want to be helpful. And that's something I see all the time. You were passionate about providing really excellent client service. And there are risks around that, the risk of helping out, even if you aren't sure whether it's something that you need to do, just going above and beyond. Now, above and beyond sounds great, but as a lawyer in this area, all I hear is the risks of above and beyond. Plus, from a commercial perspective, you should be getting paid for it. So as Emma said, there's a risk around helping the clients, wanting to be helpful, and the lines can very easily get blurred. I touch on that a little bit when I look at contract as well, really, hopefully to give some useful tips. I put personal liability on here more from a reassurance perspective, because from a negligence perspective, in the tort of negligence and in the context of your industry, in the construction industry, it will be very rare for an allegation of personal liability. So an allegation that you as the individual did something that means that you are personally liable outside the context of your company, your business. It's very rare for this to succeed. So you'll see it frequently, but take heart, I suppose, in knowing that that is something that you can normally bat away reasonably quickly by confirming that you were providing the advice in the context of the business. And that is the correct entity that should be sued. The merit and bab case. Oh, yes.
Sorry, Pat, can I just ask a question? And actually, forgive me, I'm just going to go back to professional advice, which you mentioned at the beginning of this. What actually classifies as professional advice? And sorry, because I'm throwing this at you and it wasn't part of our script.
No, that's absolutely fine. I mean, it could really be anything, Emma. If you are advising about something in the sector, if it was a surveyor and it was in relation to the condition of a house, if it was a property manager and it was in relation to, the service accounts or the condition of the property or anything that is typically within the remit of your industry, whether you have said you'll advise on it or not. It will vary, of course, as to whether you're dealing with a consumer or not, but it could be very wide. It could be anything that a court would hold that it was reasonable for your client to rely on you as the expert to provide or, to address.
Lovely. And of course, one of the really important things with this is that courts do interpret things differently as well. So judgments can evolve, can't they?
Absolutely. Yeah.
Okay. Thank you, Kat.
No, that's fine. All I was going to say was just a bit more about the merit and bab, to say that this really sent, sort of shockwaves through when it came in 2001. But the cases that I have seen since have disapplied it time and again, which really proves that this was a very unique case. It was a valuation case, but it's been applied across to lots of other different parts of the industry. And it was a case where the court held that Mr. Babb was personally liable in spite of the fact he had never even met the claimant. But it was very public policy based. His company had become insolvent and his advice was very negligent. The customer, in that case, the individual, was of, as the courts put it, modest means, and the courts found a way to compensate the claimant. So typically speaking, I would say it is unusual, and if you were to receive a claim directly against you, you should, and we as lawyers would, very quickly say, this is not for the individual. It should be pursued against the company, if at all. So moving on to the next slide, Vicky, looking at contract. So contract is king, I've said here joyfully, but it really is. So your contract is where you can limit your liability. There are so many potential risk mitigation measures that you can include within your contract. This is also where we would start and where a court would look when a claim against a managing agent comes in. This is the case with any construction professional that I deal with, but it's even more relevant to an extent in the world of property management because the scope of the services that you provide can be so varied. It is absolutely critical. It's very useful. You know, it's the first starting point for us to see what were you under a duty to do, and probably just as importantly, if not more importantly, what you weren't under a duty to do. So get it all in one place. Try as hard as you can not to start work until you've got this signed contract. Because as I said, once a claim or a complaint comes in, that's going to be the key document to evidence what you were and weren't under a duty to do. This is where you can include all sorts of helpful information that will be critical, such as who your client is and the specific scope of services, the regularity of inspections, and the real detail of what you are supposed to be doing for the client. Obviously, it's where you include your fee. That may sound obvious, but that's probably, possibly one of the most important points, and payment terms. But from a risk perspective, the limitations and exclusions that you can include in here, that you should be including in here, such as limitations of liability and limitations around the information that you receive and are entitled to rely on. I've seen lots of cases across the sector where information that's been provided is wrong. And within a good contract, you would be able to include a limitation that entitles you to rely on third-party information. It's probably a separate talk, which, perhaps we can have a conversation with News on the Block about doing. But in terms of key, nice risk mitigation clauses that you can include, I would say that the RICS has also got some good guidance on that already. But I just wanted to touch on the Javi Holmes case, because this is one that I think when I've spoken to professionals, they've said, wow. It doesn't come as a surprise to me, the way the courts have interpreted it, but I still think it is one of those ones that it's really worth just having a think about how you're communicating with your clients. I've sort of given away what the key point is here, but the court concluded there WhatsApp messages can amount to a contract. And we all know that WhatsApp and other messaging tools have become really common in business communication. They offer convenience and speed, and they're really helpful in developing client relationships. But their informal nature can give rise not only to data management risks, but they run the risk of creating legally binding obligations. So just looking at the facts of this to contextualize it, this was Javi Holmes sought demolition services from Steve Fincham. Now, it doesn't matter that it's not in the context of property management. It is something that will be applied not only to construction, but across the board, also to solicitors, accountants, etc., to all professionals. So Steve Fincham provided Javi with a quotation by email at the outset, and then there were some subsequent discussions about whether he'd be awarded the job, along with some emails and WhatsApp conversations. Now, these all led to a key WhatsApp conversation in which Javi responded yes when asked by Fincham whether he'd been given the job. And some elements of payment arrangements were discussed, in particular that there'd be monthly applications and the payments would be made every 28 or 30 days from invoice. So this was all in WhatsApp. Now, a few days after that, Javi sent a set of contract documents, including a purchase order and formal contract terms. So they included provisions that were different from those discussed in the WhatsApp discussions. Now, the works commenced and there ended up being a payment dispute, in short. And so Fincham, who had only been paid 80,000 of the £200,000 that he had submitted, he commenced adjudication proceedings for the outstanding sum, and he was successful on the basis that his quotation, and combined with the WhatsApp messages, constituted the agreed contract between Javi and Fincham. So not the formal contract that you might otherwise have thought, certainly if you were Javi, constituted the terms of the contract. And then that was subsequently tested in the High Court, so outside of adjudication proceedings as well. So this is just a reminder to be really cautious about how you're communicating and what you're communicating to the clients. Everyone's using WhatsApp nowadays. There's lots of very useful things about it, but be warned and be mindful that this case demonstrates the court's willingness to interpret that in certain circumstances as binding terms of a contract. Now, for the last point on this slide, it's really about, where do you start with a contract? Like, what's the best one? There's loads of different types. I will regularly see all sorts of bespoke ones, all sizes, shapes. My recommendation would be to use the resources that are available. The TPI Model Management Agreement, for example, this has been put together with really great attention to detail and care. I would suggest starting there. Clearly, you will have to add and strip and omit and make it the right contract for the piece of work, but I would use these resources that already exist. For example, the TPI Model Management has some of those really useful risk management clauses, such as limit. It will have a personal liability exclusion, just in case, even though I said it's rare. It will have the limit of liability exclusion, and it will have other exclusions already. You don't need to think about those or have a think about what the correct wording should be. So my suggestion is use the resources that are available to you from a contractual perspective.
Just a couple of points on this slide before we go on to the next one. The whole point, one of the key things about WhatsApp, Kat, and most of us, myself included, post-it notes, some kind of customer management system, WhatsApp, email, probably a couple of other chat functions, telephone calls. It is really, really important that we are keeping accurate records of our conversations, because when it comes to defending an allegation of negligence, the accuracy of the records and the completeness of those records can be the difference between an insurer deciding they're going to work with you to defend an allegation and an insurer saying, well, look, you might not have done anything wrong, but actually there's nothing here to prove that you've done what you were supposed to do, so we're just going to settle. So please think about the communication channels that you're using and how you might be able to bring all those records together in one place in the event that you need to. And I think the other thing I was just going to ask around this, Kat, and I know this is a really complex topic, but there's been lots of conversation over the years about what is reasonable in terms of limitation of liability. And certainly I've seen recently liability capped at sort of 10 times fee. And actually the fee is in those situations is quite low. Is there some guidance you can give around reasonableness?
Yes, they're wonderful. It is, yes, it will depend on lots of circumstances, but don't let that put you off. This is, I think, one of the things. Accountants, for example, would never do any work before agreeing the limit of liability. Solicitors, I suspect it varies, but it's certainly very common in our industry that there will be an agreed limit of liability. Architects as well, your standard REBA contracts, there'll be a limit of liability in there. It's just industry standard. It's not unreasonable. But I think what I see both in the property management and surveyors industry is sort of almost like how do we decide what the figure is? It's too complicated. It's too time consuming. And so there's not going to be a nice, neat answer here for you, apart from that it is worth taking the time. You might want to get legal advice on it, but it's worth taking the time and having the conversations with the clients about getting limited liability in there. It has to be reasonable. That's going to depend on the nature of the work, the value of the risk, the extent of the exposure that could come out of it, the value of the properties that you're managing, all sorts of things. So it could require some real, time and thought, but it really will be worth it, because if you have a claim that comes in and you've got a reasonable, properly thought out, communicated limitation on your liability in that contract, that can make a huge difference to the ability to defend it, to us being able to limit the amount that you're exposed to. And Emma, you said one example, 10 times the fee. Yes, I've seen that. It's going to depend. If it's a consumer that you're dealing with, you will need to have separate conversations with them so that they absolutely understand what it is that they're signing up to. So you want to try and minimize the chances of the court saying this was unfair to the consumer. They didn't fully understand it. So consumer is one thing. Commercial clients are different. Commercial clients, if you've had a conversation with them, if it's in the contract, then you will stand a reasonably good chance of saying that it was agreed, provided it's signed and it's not a ridiculously low and unrealistic limit of liability. Some valuers, for example, will put a limit in at 50% of the value of the property. There's a variety of different options, but do take the time to think about it, because it's totally reasonable for there to be a limit on your liability. Challenge anyone who says that it isn't. And I think this is a sector that's been slightly slower to be comfortable with negotiating. It's not an imposition, it is a very common commercial term. So I guess be comfortable.
Lovely. Thank you, Kat.
I didn't answer your question though, did I, on a nice, neat basis? But there isn't a nice, neat answer to it other than just seek advice.
And I think that's a challenge with a lot of what we're discussing today, is actually it's not nice and neat. And a lot of this is complex, and it evolves. Case law evolves what we should do, as does changing regulation, as does changing demands of clients in terms of contractual liabilities.
Yeah. Okay, Vicky, moving on to the next slide. Okay, fantastic. So looking at statutory regulatory obligations, I know you're all going to be thinking that this list is just a mere drop in the ocean of the various legislation that you navigate as managing agents, because it absolutely is. If I'd had more time, I'd love to have one of those slides that's got all the millions of ones pinging back and forth. I thought that afterwards, but this is just a drop in the ocean. And as I touched upon at the beginning of the talk as well, there are multiple different regulators who could have oversight over the work that you do. So I talked about the RSCS, and the HSE, and the FCA, and of course now there's the building, there's the BSR, there's property ombudsman, and soon there will also be the single construction regulator. So there is this increased and continued role and oversight of regulators in the industry. This has been focused on by the government, who put out a statement last year that the Labour government, this was the housing minister, that the Labour government would specifically strengthen the regulation of property managing agents as a minimum by setting standards for mandatory professional qualifications, and the government continuing to consult on this. And I think that Emma's part of the talk is particularly pertinent when thinking about regulators' role and oversight, because we are seeing an increase in regulatory claims focusing on competence. The RSCS have historically looked at competence, actually, looking both at, CPT. It's not just CPD, there's much more to competence than CPD, but looking at CPD, there's an increasing focus, for example, by the ARB and REBA. And I'm anticipating that this is something with the focus on competence that has come following everything that came after the tragedy that is Grenfell. Competence is going to be a real focus by the regulators. So moving on to the next slide and having a think about insurance now that we've gone over in a very sort of sweeping way some of the ways that you could be held liable. So insurance, what aren't you covered for? Perhaps it's a bit of a sort of feels like a slightly negative start to it, but that's what we want to have a look at for the next 3 slides at least. So there's a huge number of different insurances that you may need to consider, either for your company as managing agent or potentially if you're acting for an RMC. There could be professional indemnity insurance, directors and officers insurance, public liability insurance, cyber insurance, and the list goes on. Now, personally, I'm a specialist in professional indemnity insurance, but over my time, I've seen a range of claims and claims that my colleagues have dealt with against managing agents, most of them revolving around either professional indemnity, D&O, or public liability. Now, we won't have time within this talk to address all of the potential exclusions on the list here, and they really are just some of them. But the intention is to highlight just how different insurance policies can be and how important it is for you to satisfy yourself that you have the cover or your clients have the cover that you or they need for the work that you're doing. It's certainly something I know that the TPI is becoming aware of in particular, or is focusing on. So the scope of variation cover and that their members and others in the sector have. And there are concerns generally, and this talk is sort of part of that increased awareness around this generally. Just one example on this slide is the first on the list there, because I strongly suspect that lots of block managers will be presenting as property manager on their proposal forms to their insurers. And there might be very limited ability to add to that, to add the level of detail, to enable you to declare the breadth of work that you're doing and the additional lines of income that you're receiving in your role. For example, fees received for providing management packs, the arrangement of insurance, which is a crucial one that I will come on to look at again in a minute, and the company secretarial work that you do. Now, there's a risk that if you don't disclose the breadth of what you're doing, especially if it's less common, then your insurers could decide that you fail to provide a fair presentation as term of what you're doing, and they may challenge a claim that results around that area of work. And one example that Emma told me about, in fact, which is a perfect example, is of an agent who's taken on duties relating to the maintenance of the biodiversity of the common parts of a new estate. Now, I can tell you, dealing with lots of insurers, that typically that is not something they would anticipate falls within your remit. So you're the experts in this work, and it's really important that the insurers are told. So work with your broker, because they can help you explain the level and the breadth of the work that you're doing in this respect. So moving on to the next slide and looking at professional indemnity insurance. Now, this is probably a better understood type of policy that I suspect most people will understand, and it protects you in the event that a claim is made with allegations that effectively amount to negligence. Now, I've put the RICS minimum terms up here because really they are the best cover that is available in the market. So if you wanted a sense check, and again, this is something that you can work with your broker, but if you wanted a sense check on what cover you have and what cover you could have if you had the best cover, then the RICS minimum terms are a really good place to start. Then I've just touched on a few of the key exclusions for you to be thinking about. Now, do consider fire safety exclusions. As I said, there's often not enough space to confirm exactly what you do, but working as a managing agent will often extend to advising and doing work in relation to what would be termed a fire safety issue under the terms of your policy. For example, if you're acting as a responsible person and you're conducting or procuring risk assessments, or if you're involved in works relating to parts of a building, such as the doors, if something goes wrong, and if this is deemed a fire safety issue, will you have the cover that you need to cover that claim? Now, many insurers included vast fire safety exclusions after Grenfell. And while the RICS minimum terms, for example, are much narrower now and more restricted, many insurers will still have blanket exclusions or really broad exclusions for fire safety claims. Regulatory claims. Are you covered? PI policies vary hugely. Some will cover you for the defence costs arising from claims by regulators. Others will have no cover. Some will cover you up to a cap of, say, 5 or 10,000, and after that you would need to fund the defence cost yourself. Now, as I discussed, claims by regulators are on the rise and they can be costly. They are one of the most stressful types of claims in my experience for individuals and sometimes, for the firms. It's not just an allegation of negligence, which in itself is stressful enough. It's allegations around your professional conduct. So having access and the funds to a solicitor who can assist you through that process can be hugely helpful. So the financial services exclusion, this is hugely relevant. Emma touched on this previously in terms of the work that many managing agents will do arranging insurance. Now, I'm not, I don't know whether this is right, but information has been gathered to suggest, and Emma might be able to tell because we discussed this actually in terms of the figures. Information has been gathered to suggest that around 50% of managing agents are not RICS regulated, nor are they acting as authorised representatives, but they're still arranging insurance. So the ROCS minimum terms has an exclusion. Bear in mind, this is probably one of the most beneficial types of cover that you can get. And the financial services exclusion in the RICS minimum terms says any claim arising out of regulated activities, of which arranging insurance is one, will not be covered unless that managing agent is essentially RICS regulated or acting as an authorised representative. Now, I know, speaking from lots of managing agents, that arranging insurance is extremely common. So bear in mind, have a think now, what are you doing? Would you have cover for it? Do you need to consider taking any further steps? And now,
just to make a point on that, Kat,
Yeah.
What is defined as arranging insurance is actually quite complex. We're not going to go into it today, but I know a lot of block managers who, for example, will be involved in the process of managing claims. So what could be a claim is notified to them first, and then they then take a decision on whether that's notified to the property insurer. That would be construed, I believe, as arranging insurance. And actually, if you take the wrong decision there, so for example, you decide not to immediately notify, and that claim is subsequently avoided, you could, particularly in the context of property damage, be looking at quite a large allegation in terms of quantum. So really, really important that you understand what constitutes arranging insurance and that you understand what you are covered for and what you're not covered for, as with everything we're saying today.
Yeah. There's a couple more points on this before I move on to D&O, but an important one is fraud, because fraud is usually excluded in many policies. So any fraudulent acts by employees causing a loss. But the RICS minimum terms has third-party cover, which provides cover for any third parties who have suffered a loss. If a client has suffered one of your clients has suffered a loss as a result of fraudulent activity by an employee, then the client's loss will be covered. And I've seen time and again, unfortunately, fraud is not uncommon. And I have seen multiple fraudulent investigations, and the difference for the managing agent of having the right sort of cover here, having this third party cover, which compensates the client so that they are not liable for any losses that have been caused by that fraudulent employer, make a huge difference. And it can be, the difference between the business being able to continue and not. So make sure to check what fraud cover you have under the policy. And then finally, for today at least, just being aware of what cover the suppliers and subcontractors have, for a number of reasons when considering, other subcontractors' exclusions, because a failure to do so could mean that there's no cover available to pursue a subcontractor for any negligence or breach of contract on their part. So moving on to the next slide and touching on directors and officers insurance. Now, I caveat this by saying that I'm not an expert in D&O. I have consulted our specialist team at RPC who do this day in, day out for the purposes of this talk. But what I have been told, what stuck with me, is that they've described D&O policies as being a bit like the wild, wild west. They vary hugely, and even more, from what I gather, than your average PI policy. But they're commonly used in the context of property management, and they can be like gold dust if you have the right type of cover. So what is D&O cover? Well, D&O insurance provides defence costs and compensation for civil liability claims arising from the wrongful act of a director or an officer in the running of a company. D&O policies can also include cover for regulatory investigations, and this may be cover managing agents have obtained for themselves or equally on behalf of an RMC. Now, I asked the team here for a couple of examples of claims that they've seen. They referred to two that are very common. One is a breach of duty claim. This covers claims alleging a failure to act in the best interests of the company or its members. And an example that they gave me involved a residents' organisation with a claim by a tenant where they said that the board hadn't properly maintained the property, and they framed the claim as a breach of their fiduciary duties. Another example commonly seen relates to the mismanagement of the company. So protects against allegations of poor decisions or administrative mistakes. And an example that the team gave me related to a complaint over fencing that had been built. And in that case, the claimant said there'd been a misallocation of funds. So the wrong pot of money had been used. So these types of claims can be quite administrative by nature. Now, looking at just a few exclusions, because the exclusions vary hugely, but these are the ones that we felt were worth highlighting for the purposes of today. Breach of contract exclusions. Now, this will very much depend on the specific wording of the policy. Sometimes they will just provide for defence costs, which would be very useful in itself, so that the insurers will cover the lawyer's costs. Other times they'll be excluded entirely. So if a claim is made against the corporate entity or the directors, for example, for entry into a supply agreement that hasn't been paid, this is unlikely to be covered. But if you get the right type of cover, then you may at least be able to have the insurers pay the defence costs. Misconduct clauses. Now, these are fairly standard, and they exclude claims arising from fraud and/or criminal activity. So if a director has been found criminally liable and the claim relates to that. But these clauses are usually only triggered by either an admission or a final determination by a court. So it may be that your insurers will assist you on a, what they say, without prejudice to cover basis until you get to that point. However, I understand that there's been a recent case that means that proving misconduct on a part of a director or officer may in fact be easier, as the test has now changed and become more streamlined. So the team anticipate there will be more willingness to rely on these misconduct exclusion clauses. And then finally, prior acts exclusion. Now, this is a fairly standard exclusion that you'll see in many policies that excludes claims relating to those made or which started before the policy period in question. And it often links with what I talked about earlier about fair presentation, making sure we get the right information across at renewal or at the start of the policy inception. And it's really just a reminder to notify your insurers at an early stage of any issues, so they don't take those policy points subsequently about you having prior awareness of something. And again, coming back to it, if you are in any doubt, ask your broker, because it's their job, it's their area of experience. They can guide you on whether something needs to be notified or doesn't. So a lot to take in, I appreciate. And I'll pass back to Emma for now, but hopefully that was a useful summary.
Thank you, Kat. And just a final point on that, whether to notify. My guidance would always be, if you think something's going to erupt in terms of an allegation, notify it and do it in email. And your insurance broker may come back and say, noted, but we've discussed this with the insurer and we're just going to monitor this. But the really important point is that you have made every attempt to notify it and you've maintained a record of the actions that you take. Record keeping is so, so important when it comes to insurance. And ironically, all the online systems that we use should have made it easier. I think actually in a lot of businesses, this probably made it more complicated because we're using so many communication channels. Vicky, on to the next slide, please. So we've talked about contract, we've talked about insurance, and this last section is probably the hardest section to define. There aren't rules around how we make somebody competent. And as I'm going to come on to address, actually, any requirements for mandatory qualifications and indeed regulations still don't guarantee competency. When we talk about competency, I think there's a tendency to think that actually it's just about being qualified and being experienced. It's not. It is so much more than that. And actually, whilst we can be individually competent, quite often that the environment that we're operating in will affect our ability to be competent. And a really simple example of this is if you think about driving in dry conditions on a quiet road in a well-maintained car, providing you're experienced and you've passed your driving test, that is a relatively low-risk activity. Take the same driver in exactly the same car and put them on a very icy, very busy road when that person is, for whatever reason, under stress, and our ability to be competent declines significantly. So it's really important that we think about competency as being more than just our experience and our qualifications. And also, and Vicky, if you can go on to the next slide, please. We think about the impact of the environment that we are operating in on our ability to perform competently. And within the context of a business environment, yes, it is about the operating environment. So things that you can't control as a business leader, whether that's regulation, whether it's the economic environment. But it's also about the culture of your business. And this has come up, the word culture has come up again and again and again in the reviews post Grenfell. And a really important point I want to make, because I think perhaps there is sometimes a belief that regulation and mandatory qualifications are going to solve everything. They're not. Reflecting back on the Grenfell tragedy, yes, the Conservative government had made a bonfire of regulation, as it was referred to, but there were still around 30 key regulatory requirements that should have prevented the Grenfell tragedy. And there was no shortage of qualified people and experienced people, whether that be the firefighters or the people who supplied the cladding or the people who managed the building. So regulation and training are not enough alone to ensure that we are competent. Next slide, Vicky. And perhaps the easiest way to illustrate this is if we think about the act of planting a tree. You can take a very, very healthy sapling and you can plant it in exactly the right spot. You've read the label. I never do that. You've dug the hole 3 times the size, as Alan Titchmarsh says, and you've planted your tree. If you forget to maintain the environment that that tree is growing in, the likelihood is that tree is not going to flourish. Competency is exactly the same. We have to create a business culture where, as far as possible, we empower people to behave competently. And we have that duty both as business leaders, we have that duty as team leaders, and we have that duty also with regard to our suppliers. So think about the ecosystem that your business operates in. Next slide, please, Vicky. It may seem a little bit flippant to draw on sport for an example of illustrating what impacts our ability to be competent. But actually, it is probably one of the best examples because it is relatively simple to see the multitude of factors that can impact how we perform. So for today's example, we're going to look back to the 2014 World Cup. For those of you who are into football, and I'm not, so any comments on my assessment here can please go into the chat and I will correct it for the next time. 2014 World Cup was held in Brazil. And Brazil were the hot favourites to lift the title. I think it was for the 6th time. They were playing on home soil. They had one of the world's greatest attackers. They had a fantastic defence, and they're performing well in the build-up to the tournament. But instead of going on to lift the title, Brazil collapsed in the semi-final, suffering a 7-1 defeat to Germany. So what went wrong? And there is loads of commentary on this line, so I've picked out some key points. So I referenced Brazil's amazing attacker. That was a guy called Neymar, and he was actually injured in the quarterfinal, so he couldn't play in the semi-final. Not only did Brazil go into the semi-final without their star attacker, they also were without their captain, Thiago Silva, because he'd been suspended after a yellow card. So they're going into this really, really important game. They're lacking confidence because they know that they're 2 men down and they're really key people to the team. They're also lacking leadership because they've lost their regular captain. Pundits also suggested that Brazil had become so accustomed to winning that they didn't have the mental resilience to deal with the shock of lots of early goals from Germany. They weren't able to stand back and change their game plan. And that challenge was compounded because their coach was also accused of failing to adjust strategy. They got so used to playing to the same game plan that when they needed to change it, they weren't able to change it. Added to that was the pressure of performing in front of a home crowd, with a home crowd who had huge expectations of what they were going to deliver. Now, if we translate that into a work environment, I think all of us will identify factors that could impact on the most competent individual or team. Think about Brazil's reliance on their brilliant attacker and also on their captain. They were over-reliant on 1 or 2 key people. That's a real problem in any industry where recruitment and retention is a challenge, as it is in property management. Illness can leave a team short on resource. What's your plan, for example, if 10% of your team, 15% of your team are out of the office for a week ill? Big problem at this time of the year when we're dealing with flu, we're still dealing with COVID. They hadn't got their captain and their coach wasn't doing what he was supposed to do. So poor or diminished leadership. Leadership has a massive impact on business culture. It has a massive impact on risk. If a business is led by people who are risk takers, who actually quite often make quite successful business people, the business is probably going to be a higher risk business. They suffered from pressure and expectation. Everybody was expecting them to win. Everybody was expecting them to deliver. Pressure comes in lots of forms, from the pressure that's surrounding us in our daily lives, so what's going on at home impacts how we work, to the belief you've just brought in a star property manager, you know that they're fantastic, so you've straight away loaded them up with 6 really demanding blocks to manage. That's really, really challenging. Lack of mental resilience. I've highlighted the fact that Brazil was so accustomed to winning that when they were hit with this onslaught of goals, they didn't quite know how to respond. Planning for disaster is really, really important. If you can test what your team are going to do if the worst happens, if you can test what your team do when they're 1 or 2 people down and you can get through that, that will put you in a much stronger position to perform when things really do go wrong. And finally, failing to change strategy in response to evolving circumstances. Really good example of that. Regulation. You're being hit by lots of changes in regulation. Very difficult to respond to that, particularly when some of it's quite opaque and you're not quite sure what to do. Equally, what's going on with the economy places demands on us. Changing demands of leaseholders. How do you ensure that your business remains agile enough to deal with those changes? So there are really important things that can affect competency and can impact how we perform under pressure. And each of those, I think, is something that every business, and certainly every business I've worked in and every business I've worked with, has had those challenges. Vicky, next slide, please. I'm not going to talk through this slide in depth, but quite often when we think about culture, one of the questions I'm asked is, where on earth do we start? And that's a really difficult question, that there isn't a rule book for getting culture right. And actually culture is massively, massively impacted by people, and governing, controlling, ruling people, getting them to do exactly what we need them to do day in, day out is very, very difficult. But I think if within your business you have the questions that are on this screen at the back of your mind continuously, and they are things that you subconsciously ask yourselves as regularly as possible, you are going to be going quite a long way towards developing what I would call a good, healthy culture. And that benefits not only your clients, not only your leaseholders, but actually also your team. And it's certainly something I think that when people are thinking about recruitment and retention strategy, emphasising positive business culture is an increasingly important thing. Vicky, next slide, please. Skip through this slide, thank you. And forgive me, the reason I've skipped through that slide is not because it's incredibly, incredibly important. It was Peter Apps's quote from Show Me the Bodies, which basically said that if you think the consequences of doing something wrong are going to be absolutely massive, no matter how remote, you cannot ignore them. And that is really, really important. I've put 3 questions back on the screen that we started this with: contract, insurance cover, competency, and finally, culture. Does our culture support competency? These are the questions that we need to get used to continuously answering. These are the questions that we need to ensure that we are aware of how to respond to. And these are the questions where we need to be asking other professionals, whether that's insurance brokers or actually our peer group in terms of the industry, how we're dealing with it, how we are dealing and responding to these points. Really, really important point about managing risk is that you are only ever as strong as the weakest link in the chain. Your chain includes not just your team, not just your suppliers, but actually other block managers. And if other block managers don't get this right, that reflects and impacts risk across the entire sector. It is quite often difficult to share information around risk. It is often commercially sensitive, but I would encourage this industry to share as openly as possible, because it really can make a significant difference in terms of mounting a strong approach and being a well-managed risk as a whole. And I'm saying that with a reflection on the sector. Thank you very much for being a brilliant audience. I can see we haven't got any questions. We have got 2 minutes left. Does anybody have any questions? In that case, Kat, I'm going to ask you a question, and forgive me for putting you on the spot. We talked earlier about making sure that professional indemnity underwriters are aware of what they're insuring. Policy documents should always include a business description. Very often, where a block manager is concerned, I'm seeing a business description that might be, for example, surveying firm. Now, obviously, if they are a RICS regulated surveying firm, that's fine. But perhaps more worrying, estate and letting agent. Is the business description on the policy document, is it important that is accurate?
I mean, it is, but what I think will be more important is the detail within the proposal form that explains what it is you do, because there are lots of different terms that people use, but the devil will be in the detail, explaining what services you actually provide, where you get your income from.
Yeah. And leading on from that, I think one piece of guidance I would offer is if your proposal form just allows you to tick a box to say property management, or you're completing a renewal declaration, which might even not give you the chance to tick property management, I would break down your turnover. So break it down according to what you're earning from management fees, from the completion, for example, of management packs, LP1s, from the arrangement of insurance, from, for example, company secretarial, and indeed any other revenue streams that you are generating as a business. If you do that, I think it is quite difficult for an insurer then to turn around and say, we don't understand what you are doing.
I completely agree with Emma. Yeah.
Thank you very much, everybody. If you have any questions for Kat or I, our contact details are briefly on the screen, but you will also find both of us on LinkedIn as well. Thank you.
Thank you very much.